Welcome to Aging in Place Strategies and Answers with Linda Prio. Will it be possible to remain in my home as I age? Do I feel safe in my home? How do I figure out how much support I will need when my health needs start to change? What if I decide to move into a community instead? Which community will meet my needs now and in the future? Who will play a role in helping me with decision making? Do you ask yourself these same questions? Aging in Place Strategies and Answers can help you gain practical knowledge that will help you create your own Aging in Place roadmap. If you are already a care partner, a power of attorney, or in crisis mode with your Aging in Place strategy, you will learn what you need to know that you don't know. For over 20 years, I have been marketing Aging in Place services to clients and educating families and healthcare professionals in how to put aging in place strategies into place. When you utilize aging in place, you are allowed to choose where you want to live and make those decisions so that you can retain your quality of life. Listeners, you are getting ready to listen to part 2 of my interview with attorney Rudy Beck. And the subject matter of this interview was really about families and their extensions, but also other relationships that have been created through second marriages or partnerships. They're about the importance of planning so that we don't disinherit or ruin valuable relationships at the time of our passing. We want to spend some time analyzing what legal strategies we need to put into place so that those relationships are protected and that our goals and decisions are actually in effect at the time of our death. And so we are going to be discussing the value of whether or not a postnuptial or a prenuptial agreement is important, as well as beneficiary designations and how to use those. So, join me as I continue my conversation with Rudy Beck. Rudy, do you think a prenuptial or even a postnuptial agreement is important in these blended family relationships or partnership relationships?
Absolutely.
Okay.
Critical.
We don't hear about them so much anymore. I mean, I'm not in the law firm every day, so I'm not hearing about them, but I just don't hear people talking about it.
Well, when people are in love and they're planning on getting married, really that's the last thing they want to deal with.
Right. Well, it can spark conversations that are
you mean
unpleasant.
money's going to be a factor? Well, if you don't do anything, it'll be a big factor.
Mm-hmm.
If either of you have children by a prior marriage, let's just say John and Mary,
Mm-hmm.
and let's reverse the tables from what one might usually expect. Mary's bringing in $2 million of assets, and John's bringing in 300,000 of assets, but they want to get married.
Mm-hmm.
Um, John's got 3 children by his prior marriage, and Mary has 1. Well, what happens if Mary dies first? And she dies without a will, and they don't have a prenuptial agreement, or even for that matter, a post-nuptial agreement.
Right.
What happens? Well, there's no children born of the marriage. So Missouri law then says what happens. And under the circumstances, Sean would end up with about a third of the assets, and Mary's daughter would end up with 2/3. Now, maybe that would be what they would both want to have happen anyway. I don't know.
Yes.
Reverse the situation. John dies first.
Mm-hmm.
Well, Mary now gets those assets. Plus, she gets a 1-year support allowance. She gets other things permitted by Missouri probate law. So rather than having people go in and fight all that out, and oh, for God's sake, please don't just use beneficiary designations thinking you've got it covered.
Okay. Because we're going to talk
Because,
about that next.
yeah, we will. We most certainly will. And I'll get into the reasons on that when we do. Uh, there is no substitute for having a couple sit down and talk about what they want, helping them understand what they can do. There's very little you cannot do. Pretty much, what do you want?
Right. Exactly.
And
Just
and as long as it's
figure it out.
clearly stated and both sign off, and by the way, in a prenuptial agreement or postnuptial agreement, each party has to be represented by legal counsel. Now, they can both be sitting here agreeing upon everything, and one lawyer, like me, we could prepare the document for my client,
Mm-hmm.
and the other member of the couple is sitting there saying, well, I agree to everything. Why do I need a lawyer? Because under our law, it's going to be assumed you don't appreciate what you're signing until a lawyer representing you says it's okay.
Yes.
Um, oh, so if you want the agreement to be enforceable under Missouri law, another lawyer has to sign off on that saying, well, I've advised you about all this. You understand it, yes. And I'm telling you now, based on what you've told me in our discussions, I will sign off of this on your behalf.
Yes.
Um,
Yes.
Terribly important. Well, we don't want to spend that extra money.
Right.
Well, guess what? It's going to cost a hell of a lot more if a dogfight results
Yes.
later
Yes.
on, and it could tear what otherwise would has a pretty good relationship among children by first and second marriage. It could tear it completely apart.
Absolutely.
Um, so you don't want to go there. You
No.
just don't want to go there.
No. If you figure that, you know, just figure out the cost of preparation for those documents as opposed to going into court. And that ought to just get you into a meeting, right? Because people are
Usually
unprepared for
usually
them.
before the first step is taken to courthouse door, you've spent a lot more on the lawsuit than you will have the postnuptial
On the
agreement.
preparation of the documents. So,
Right.
yes, I hope listeners that you are listening to what Rudy just said. And what we're trying to do is to lead you down a path that will help you to understand the importance of just getting this in writing and make sure that you're comfortable and whoever you're planning with is comfortable. And then everybody has been updated on the documents. Okay,
Yeah.
so you mentioned it, you brought it up, and so I think we have to talk about it. And it's those beneficiary designations. What is the purpose of them in pre-planning, and should we review them from time to time?
Um, the answer to your second point, yes,
Yes, yes, and
they
yes,
should definitely be reviewed. Um, Sometimes somebody you named as beneficiary might have died several years before you did.
yes,
Well, how was that beneficiary designation set up? Was it set up with what we call the LDPS designation behind it? I designate Jim, Mary, and Ellen in equal shares. Okay, well, what happens if Jim, Mary, or Ellen predecease you?
yes.
If you don't have LDPS behind it, the surviving two are going to take.
Mm-hmm.
If you have LDPS, which means lineal descendants per stirpes, that means children of a deceased beneficiary take what would have been that parent's share.
Yes.
Um, Either way, it's a poor substitute because what happens if surviving children of a deceased beneficiary are under the age of 18.
Yes. What do you do then?
You got to go to probate court and get a conservatorship established is what you have to do.
That's correct.
But if you have a living trust, you avoid probate
Hmm.
and you've already anticipated what might happen if one of your designated beneficiaries dies before you do,
Hmm.
leaving minor children surviving, or for that matter, an incapacitated child or grandchild can be provided for in the trust.
Yes.
So again, there's no need then to go to probate court to have a conservatorship set up for that incapacitated beneficiary. Um, that's one of those situations again where the money spent to do it well the first time is going to be far less than money spent because it wasn't done well the first time around.
Yes. Yes.
Now, if there's no time, if on Monday morning the doctor looks at you and says you're going to be dead within a few days,
Hmm.
then run to the bank, do a beneficiary designation. Um, if you own real estate in your name alone, take copies of your deed or deeds, run to a lawyer and have a beneficiary deed prepared.
Okay.
It's better than nothing because you avoid probate.
Wonderful. That's great advice, Rudy. And
Um,
because we don't understand when we don't see the importance of planning, you're going to get into crisis planning. So this is what you're doing for us here. Is great advice for crisis
I
planning.
mean, there have been, well, several times where somebody finds out that they don't have long to live.
Hmm.
But if they have a good handle on their financial affairs, we've been known to kind of drop everything and put together a living trust for them,
Hmm.
um, so they can avoid probate.
Yes.
And in second family or blended family situations, that can be incredibly important. Um, it's important anyway, but gosh, um, in those blended family situations that you had mentioned, I can think of nothing more important
Hmm.
than taking steps, though. Just do it far enough in advance, not when you're under pressure because you've got a bad medical report,
Hmm.
but when things seem to be going pretty well.
Yes.
Um, Take your time, think it through, get with a lawyer that's going to help you think it through
Hmm.
if you have questions about the right thing or the wrong. But like I said before, there's really no wrong way to do this. Um, it comes down to what do you want?
Hmm.
And if sometimes though the couple can't figure out what they want.
Yes.
One of them wants one thing and the other one wants another thing. In which case we can't do a prenuptial agreement.
Hmm.
Can't do it. You ask yourself, well, how is property held? Oh, well, I just put it in joint names with a couple of my kids. Oh, really? Well, when'd you do that? Oh, just a month ago. And how long have you two been married? Hmm. Guess what? Your children might have a right, your spouse may have a right to contest that move.
Hmm.
Oh, really? Well, yeah, he or she didn't consent to that. You're trying to
Yes.
turn, you're transfer, trying to transfer property acquired after the marriage um, without his or her consent. You've opened up a Pandora's box. It will not work the way you hope it does.
Yes.
Of course, if there's a lot at stake, I can pretty well assure you it won't.
Yes. Yes. And I think sometimes, Rudy, people think they don't have a lot. You're laughing. What made you laugh about that statement?
Because well, I'm just reminded of early in my practice, I had a lady in her 70s. Now, keep in mind, this is when I was a kid lawyer, around 29 or 30 years old.
Okay.
And she was from what we call the Frenchtown area here in St.
Oh,
Charles, which is
yes.
one of
Okay.
the older parts of St. Charles.
Yes.
And she came in the middle of winter, her little pillbox hat, purse across her forearm, her nice winter coat. And she came in and informed me, Mr. Beck, I want you to do a living trust for me. I knew where she lived. And I'm thinking, so I tried to explain to her that maybe a simple will would be sufficient or a beneficiary designation. She only had one daughter.
Mm-hmm.
And she said, well, no, Mr. Beck, isn't it true that if my daughter dies before I do, my granddaughter, who's only 16, she can't take control of those assets. That's correct. So we'd be in probate. Well, yes, whoever would step up to represent her would be in probate. That's true. And isn't it true that if I don't even, if I have a will and not a trust, anything my daughter inherits from me will be a matter of public record? I said, yes, ma'am. That's also, I'm going, what the heck?
Who am I talking to here?
Yeah. Well, I'm talking to an informed client.
Yes.
I said, that's also right. She said, well, how much more are you going to charge me to do a trust as opposed to a will and these two power of attorney documents? Back in those days, it wasn't much. It was $250 more.
Yes.
And she said, so for 250 more, you're telling me that maybe I don't need a trust. And I said, no, ma'am, I'm happy to do your trust for you. Uh, so that was a lesson learned. Uh, she didn't have a lot at all. $20,000, I remember that specifically. $20,000 in a CD, between $2,000 and $3,000 in a checking account, one car, and this small house in Frenchtown. That was
Yes.
it.
Uh-huh.
But she knew the advantages of a living trust, which would cover a probate avoidance. And should something happen to her daughter and her, because her daughter was driving her back and forth to the doctor a lot,
Right.
if something happened to both of them while the granddaughter was still young, or at least so young that she didn't want her to have full control of the assets. And she said, there's no way I want her to have that responsibility just because she's 18 or older.
Right. Right.
I said, okay, then I'm happy to do the living trust for you. And she was more than happy to pay the extra $250 for it because she understood that essentially that was buying an absolute peace of mind insurance policy for only $250 more
Right. Right.
and a one-time premium payment at that. She wouldn't have to repay that every year.
No,
Uh,
exactly.
so it, so I've learned that was a lesson well learned by me. Never assume that somebody who isn't worth a lot wouldn't be better off having a trust.
Mm-hmm.
People generally are.
Yes.
And the beneficiary designation can be utilized if there isn't time to take care of everything else. The
Yes.
beneficiary designations are easy to accomplish.
Yes. And then you may just find that once you accomplish that, then you're ready to do the next level planning because
Correct.
now you have peace of mind with your partner or in your blended relationships. You've come to some feeling that you're on solid ground and that your relationship is such that you can go to the next level.
And Linda, let's just say again, one spouse brought a lot more into the marriage than the other. And the spouse who brought the most in would like to see his or her children benefit more. Okay. But at the same time, they want to take care of the spouse they leave behind.
Exactly.
A trust works that out perfectly
Hmm.
because you can designate all or a certain portion of that big chunk of money to be held in trust, perhaps with income only paid to the surviving spouse.
Yes. And I see that and hear about that in my industry as people are aging. Maybe they've been a partner for a long time, but now they decide there's no assets going to my spouse or to my partner if I pass, and now's the time I need to accomplish some things.
Correct.
And so that is also a time in somebody's life where they might finally do some planning. So, friends, listeners, I think you've learned a few things that you need to know today. I think, Rudy, what I learned in doing our estate planning is that we started with one thing, and every year on the calendar date that we establish the trust, we look it over. What's changed? Where are we now? Have we done? Is everything in the trust? What do we get rid of? We kind of look at the nuts and bolts of what we still own and things like that.
And that
But
what you just said is critical. When I was a younger lawyer, I thought, oh, well, I've got to send a reminder letter out every year. Well, when you're only 26, 27 years old or 30 years old, that year seems like a long time.
Mhm,
But now it goes by in a blink.
it does.
And so I didn't get that. And I would have people perturbed at me because I had done a trust or whatever for people who, when they first came in to see me, were in their 50s. And I'd said, Rudy, we just did that. No, it's been a year. Yeah, Rudy, we just did it. So we've kind of drawn a line in the sand, assuming that there's no health problems in existence.
Right.
We basically say for people who are 60 years of age and younger every 3 years,
Okay.
every 5 years,
Yeah.
and people who are above 60 every 3 years.
Hmm.
Obviously, if there's a known health problem, we might even touch bases every 6 months.
Yes. Yes.
Um,
As you find that your healthcare needs are changing, a lot of
and
things can
Linda,
change.
that also reminds me, we make it a practice of following up with people after a trust has been signed
Hmm.
to make sure they have followed our instructions on putting assets in the name of their trust.
Yes. Yes.
We've had people come in who never were told how to do that by a lawyer who drafted their trust.
Yes.
So they've had a trust for 15 years, 20 years. And I ask, okay, tell me about the assets in the name of the trust. And I get this blank look like,
What are you talking
well,
about?
the will says that everything we have goes into the trust. I said, and that means everything goes into probate first. What? They, what? I say, yeah. Anything you die that's in your name alone when you do die has to go through probate.
Yes.
And your will then direct where it goes, but first it goes through probate if there's no beneficiary designation
Yeah.
or no joint owner. Well, we were never told that.
Hmm.
Well, that was a big mistake by whoever they went to begin with.
Yeah. Yeah.
Um, so in final, the other myth to tear away, if I have a will, I don't have to worry about probate. That's true. You don't. You're going to be dead. But
A little
but
legal humor.
but your family can, probate's a good process. It's just that if there's no conflict among family members, the only real winner in probate is the lawyer.
Right.
Um, we get paid anywhere, depending on the total value, anywhere from 3%, 3.3% to maybe around 2.5%.
Uh-huh.
The percentage goes down as the total value of the assets goes higher, but it's still not never less than 2%. And on the first $100,000, it's 3.3%. So,
Yes. Yes.
you're going, really? Oh, and by the way, the person that acts as your executor or now personal representative, if you don't have a will, they're going to get paid the same amount. Oh, it's not the probate court that gets paid a lot of money. If something goes through probate, it's the lawyer
Yes.
and the person that acts as the personal representative.
Hmm.
Again, a trust lays all that out.
Yes.
It's much easier for the lawyer to handle trust administration than it is probate administration. So
Yes.
we charge less.
Yes. Yes. There's so much to know. And you, and your experience have really helped us today to at least have some tools in our pocket that we could go and know what terminology or at least approach a lawyer such as yourself saying, I heard on Linda's podcast, this is what I need. So can we start there? And then, as you know, in your role, that you're going to educate and counsel people into what else they need to know in their particular life and in their particular plan. I always say that whenever there's a change in what you own, who you're with, or your health, it's always a good time to review what you have in place. Because, as you say, the years go fast, but things change in those years, and
They do.
you just
It,
want to
you
be
know,
prepared. And a tune-up is much less than a new product.
I can't tell you the number of times where a particular child has been excluded or their share substantially diminished from the other children, only to have 5 years or 10 years later, that same client walk in with a big smile on their face saying, well, John's really grown up a lot, and
Mhm.
now I want to include him with a full share.
Yes.
And I just celebrate that with them. Um,
Yes.
uh, if they don't get back in here, though, what
It
they've
doesn't
already written
matter.
is going to be held in place, and
Yes.
not what they want. So that's why we automatically send out a reminder letter now, either 3 years or 5 years, just to remind people you need to be thinking about this.
Hmm. Yes. Yes. Rudy, I always end my podcast with a caregiver tip. I know you and your wife are going through that role right now. Um, is there anything personally or professionally that you would share with my listeners? I always like to support the caregivers who have a lot on their plates.
Well, first and foremost, like we started off with, the healthcare durable power of attorney and the financial
Hmm.
durable power of attorney. And when I say durable, the document, each of these documents has to have a statement to the effect that this document will survive my becoming incapacitated. So that means it will be durable.
Okay.
It continues to exist even though the person who signed it is no longer capable of signing something different
Okay.
or making their own decisions about their health care. And for God's sake, oh, with the financial power of attorney, a mere statement that somebody is suffering from mid-stage or advanced Alzheimer's dementia doesn't mean they still lack capacity to decide how they want things to be distributed. I can't tell you the number of times we've seen people think that, oh, well, that's all I need. Now I have the authority to act. No, you don't. The doctor has to be very specific in saying, oh, they don't have capacity to manage their financial affairs. Um, Again, somebody runs to get a doctor. Well, the doctors don't appreciate those niceties.
Mm.
So you need to be consulting with a lawyer before you get the letter from the doctor to activate that power of attorney.
Yes.
Or some power of attorney documents and say this is immediately effective and you don't need a doctor's statement.
Yes.
Linda, we could go on, and I know your time is limited this morning for the podcast, but oh, there's a lot more I'd like to mention to you.
I know. I know. And so this is good because I know from your experience that you have just seen it and lived through it and helped your clients walk through these situations as well. So whether or not you all of a sudden decide that, wow, we're in a snowball that's going downhill, attorneys know how to crisis plan. Okay. So
True.
just know that. But if you're not, in that crisis mode, there's a time that you can spend getting educated and then thinking through the decisions that you want to make and then getting them in black and white and filed so that you know that you have what Rudy has said over and over and over again, peace of mind. And I will tell you that that was my experience, Rudy, is that when I had finished, and I feel like my husband was the same way, when we had finished the initial plan, we felt, okay, good. We've got something in place. We've got something to work with. Then we came back and we changed things because, in 3 to 5 years, our kids were married. Our kids had kids. And so now we're in a totally different phase of life and we needed to plan appropriately for that. And when we left, we thought, okay, we've been educated. We have discussed options. We have now delineated what needs to happen and we feel good about it. And then I even ran into you and shook your hand and said, hey, it's good to see you, Rudy. So thanks for the valuable service that you've provided. I know you serve, St. Charles County, but you also serve, where else does your firm serve? I can't remember.
The whole surrounding area.
The whole surrounding area.
St.
At
Louis
East
County,
Central and Missouri and West Central Illinois.
Yes.
So we want to make sure that if you're looking for a firm such as the Beck, Lenox, and Stoltzer estate planning and elder law firm. I'm going to have all of your contact information in the show notes for my listeners, but feel free to give them a call, make an appointment, and then listen again to Aging in Place, Strategies and Answers.
And Linda, I have to mention, when they call, don't ask for me.
Oh, don't ask for Rudy.
Because I am continuing to be involved for those families that I have represented for, well, in some cases, for the whole 50 years.
Yes.
I'm into a 4th generation on some of those families now.
Yes.
But I'm phasing out.
Yes.
And I've got 3 other lawyers here now who are incredibly capable and very good at doing what we have done for a long, long time.
Yes, they've learned from the master, and then they brought their knowledge
well, thank you for
and
that,
experience as well. So thanks again for being on my podcast. I greatly appreciate it. It's been wonderful working with you all these years.
Thank you, Linda.
Mm-hmm. Listeners, do you need a speaker for your group? Or perhaps you would like to know how to access my YouTube channels? Please check out my website, seniorsupportstrategies.com. On the website, you will even find more details about how to get a personal consultation. Thanks for listening. Thank you for joining me today. Please remember that this podcast is intended as education and not advice. Don't forget to share this podcast with family, friends, or colleagues who want to learn how to age in place, but also share this with those who find themselves in crisis mode. Please go to my website, seniorsupportstrategies.com, for more information. When you subscribe to Aging in Place Strategies and Answers, you gain access to premium content and professional tips on creating your own Aging in Place roadmap. As always, I value the time you spend with me.